back, everybody. Thank you for returning from lunch. It's good to see everybody still. We'll go ahead and get started for the afternoon session. Our next presenter has devoted her entire legal career to serving the people of Indiana, from the Public Defender's Office to the Prosecutor's Office to the EEOC and all the way to the Supreme Court. Her career with Indiana Supreme Court began in 2005, primarily as counsel to the 7-member Judicial Nominating and Qualifications Commission. In case you didn't know, the commission serves a dual purpose. It investigates and prosecutes allegations of judicial misconduct and recommends lawyers for appellate vacancies. She served in that role dutifully until about 2.5 years ago, when she was named by the Supreme Court as the new executive director of the Indiana Disciplinary Commission. She replaced the now retired Mike Whitty and hit the ground running, including coming up here for her second time to talk to us about the commission. As I was reading about her distinguished career, I was impressed with her sort of mantra that the more she can teach us lawyers about how to practice ethically and professionally, the less she has to do disciplinary stuff. So the prevention is always better than the discipline. If the former can reduce the latter, everyone wins, especially our clients throughout the state and all of citizens of Indiana. And we are very gracious for her to be here today. Her favorite book is, I better write this down, The Wisdom of Big Bird and the Dark Genius of Oscar the Grouch. Please join me in welcoming Adrienne Meiring.
And if that doesn't tell you everything about me right there in my favorite book, the dual sides of my whole existence. And for those of you that don't know anything about that book, it is the biography of Carol Spinney, who was the Muppeteer for both Big Bird and for Oscar the Grouch. And no spoilers here, but the most interesting part of the book is that he asked his future wife for a date 3 different times. She turned him down 2 times, and then on the 3rd time, she finally said yes, because she believed he was just so persistent that, he should give him a chance. He later admitted that she had changed her hairstyle 3 times, and he thought he was asking a different woman on a date. So, my quirky sense of humor and the 2 sides of my personality right there. So, I'm here today to tell you about the Disciplinary Commission, what we do, and how we do it. And so, there are 2 aspects of my existence. There's the preventive side, and there's the reactive side. And we did a lot this year, the last 18 months, on the preventive and outreach efforts. We issued 4 advisory opinions. I've really tried to step that up since I took over as the executive director, in order to give people some guidance on the guide rails of what to do. And what we found after holding a town hall with representatives from across the state is conflict of interest baffles many people on what they can and cannot do in terms of representation, and when should they decline representation. So we did a 3-part series of advisory opinions on conflicts of interest, and our format is to give the short and easy rules, and then hypotheticals of real-world situations to guide people through how to apply the rules. And then everybody's favorite, the ethics of getting paid. So, and we'll go through that in more detail later. Okay, so the part people don't like hearing about as much, the more reactive or restorative efforts. But as you can see, given the fact that we got almost 1,400 complaints in the last year, very, very small percentage actually resulted in discipline of the lawyers, and that includes caution letters, private caution letters. So the good news is most of the mail you get from me is very, very thin and says, a grievance has been filed against you and it has been, yay, dismissed. So that's the good news. It's like 2% of the grievances that we receive are viable and have anything to them. That's the good news. Now, the other aspect of my job, because we created an umbrella agency, because I have all this experience with the Judicial Qualifications Commission, they didn't want to lose that when I became executive director of the Attorney Disciplinary Commission, we created an umbrella organization called the Office of Judicial and Attorney Regulation. The two commissions are separate, but the same staff provides services for both. So Mark Carnell in the back, sometimes he might be doing attorney discipline matters, sometimes he might do judicial qualification. It depends. We've got different staff members doing all kinds of things. Now, the bad news on the judicial discipline side is the complaints are on the rise. The good news is that the viability of complaints still is roughly at about 3%. I'm not really sure why complaints are on the rise in judicial discipline, other than people are more anxious since COVID, isolation, cases were delayed, and so more things started to come to the Judicial Qualifications Commission. But as you can see, again, small percentage of matters that actually raised viable ethical concerns. All right. So let's demystify what the Disciplinary Commission actually does. Our actual purpose is stated in Admission and Discipline Rule 23, but here's the short version. We have two purposes: to protect the public against bad lawyers and to protect good lawyers against bad complaints. Okay? So when things come to us, we're not just looking to get somebody. It is our purpose that we are to protect good lawyers from bad complaints. All right. This is our commission, and in the center is our chair, and this is also a educational note. Update your photos. Any of you who know Ed Sullivan, who's from the region, does not look like that. That's the best I could come up with. So, we have, it's a 9-member commission. 7 are lawyers, and then we have 2 non-lawyers. The lady with the long hair, Molly Kitchell, is one of our citizen members, but I have heard her referred to as almost playing a lawyer on TV, because she's been on the Judicial Nominating Commission twice, and she's coming up on like her 8th year with the Disciplinary Commission. So she is as knowledgeable as many attorneys I know. And Terry Webster just started. He's in the left-hand corner there, and he too has hit the ground running. If you ever meet him, loves to fish. Tell him your favorite fishing hole, and you've made a friend for life. All righty. All right, so you have the misfortune to get a grievance submitted against you. Now what? Well, first thing, don't panic, okay? Understanding the process, I think, helps a lot. As I indicated, the vast majority of things that come before us come by way of somebody complaining, a grievance. That's not the only way that a matter might spark the commission's interest. Sometimes there's self-reports. For example, if someone is convicted of drunk driving, the rule mandates that you must report that to the Disciplinary Commission, any conviction of any crime, or a mandatory report by another lawyer. If it is substantial and goes to the fitness to serve as a lawyer, or honesty or trustworthiness, and there's actual knowledge, you must report to the Disciplinary Commission. So that first box is kind of the starting place of an allegation has been raised, and most of the time we will, through our screening, determine that it does not raise an allegation of ethical misconduct. It doesn't fit within the rules. A lot of people complain they didn't like the way their lawyer handled something, but that's not an ethical issue. However, there are grievances which at least raise a question, and we need to get a response from the lawyer. Context means everything. There's often two sides to a story, and our starting place is to ask, tell us about this. Is it true? Is there more information that will help us decide whether there's a violation or not? So, and again, many times when a lawyer gives us a response, those get dismissed too. So my first message to you is do not freak out if you are asked to submit a response. And don't become defensive. This is an opportunity. It's like the word crisis. With crisis is opportunity. And you have an opportunity to explain the situation more fully so that the disciplinary commission can understand why you may not have committed ethical misconduct. You must respond to a request for information. If you do not, though, it can lead to a non-cooperation suspension. I think a lot of people don't realize that. So don't ever not respond. Don't ostrich it. Because I hate signing those motions for non-co-op suspension. If the response doesn't answer the question, there may be other witnesses that we need to talk to, maybe depositions need to be done, maybe certain records need to be accumulated, like bank records. It will then be docketed for investigation, and that's that third box. All right. People often ask, what's the difference between deciding that something is a caution letter situation versus filing charges? And Admission and Discipline Rule 23 does allow for me to recommend to the Commission to issue a private caution letter. Normally, these are less substantial violations of the rules of professional conduct or situations where the lawyer, upon realizing that a mistake was made, cures it. For example, unearned fee, and the lawyer then refunds part of it to the client. That might be a situation where there is a caution letter as opposed to filing disciplinary charges. And the rule requires that facts of the allegation be in the letter. If there is some method to remedy the situation, for example, like Mark on trust account stuff, maybe a remedy will go to trust account school. And a deadline to create, this just ran out of juice, the PowerPoint. Yeah, it just needs to be plugged in, the computer. All right, so let's talk about the next phase of the process, which is, oh no, charges have been filed. And to understand, I don't make the decision about any charge that gets filed. I have a client. My client is the 9 people that I just showed you. They make the decision on whether charges are filed. Just like corporate counsel representing a board of directors, I go in and I make recommendations to the commission, but the commission ultimately makes the determination as to whether disciplinary charges are to be filed. And that's based on a reasonable cause standard, something akin to probable cause. And they have to determine not only that there's reasonable cause that a violation occurred, but that is substantial enough that it warrants public discipline. Okay? Once charges have been filed, then the respondent lawyer is required to answer. This is different than in judicial discipline where it is a permissive answer. If lawyers do not file an answer on a discipline case, then they can be subject to a complaint, a judgment on the pleadings. Again, you don't ever want to ostrich because effectively you don't ever get your day in court. So, all right. All right. So, when I was a kid, I loved those books where at the end of it, it would tell you a storyline, and then it said, choose like you are a deep sea diver, and an octopus, a giant octopus comes out. Run away, go to page 7. Go fight the octopus, page 23. So, we are going to choose based on what you want to hear. So, why don't you choose our first category? Your categories are, best being advisory opinions, trending topics, per curiams, or on the horizon.
Let's go with trending topics for 200.
All righty then, let's go with trending topics. All right, so here are some of the trends that we saw last year, because I will tell you that there were only 3 per curiam opinions last year. There were a number of other disciplinary orders, but the ones that really were meat and potatoes where the court felt like they had to write something additional about it, only 3. That's good news. Thank you for trying to work me out of a job. So what I want to talk about is some things that we saw that may not have hit as discipline, but we saw a lot of grievances. They may have been private cautions. And one of the first areas is attorney bypass. We are still getting a lot of grievances about violations of what's popularly known as the attorney bypass rule, particularly in family law cases. And for those of you that don't know the colloquial term, this is Rule 4.2, which requires when representing a client, you cannot communicate about the subject of that representation with a person that the lawyer knows to be represented by another lawyer. Unless, again, everything in law, there's always an unless you have the consent of the other lawyer. And if you'll remember, in the last about 18 months, there were 2 big cases on the issue of attorney bypass. In re Martin and in re Steele. In re Steele stood for the proposition that even if you are representing yourself in a matter, you must comply with Rule 4.2. So just because you go in, you have a neighbor dispute, and you're representing yourself, and your neighbor is represented, you can't go straight to your neighbor to work out the dispute. That would be a violation of Rule 4.2. What is of more interest is in re Martin, which was a situation involving a divorce. Husband could not get along with his various significant others, because first case was with his first wife, post-dissolution proceedings, custody matters. He had been remarried, gets into a situation with second wife in which criminal charges get filed, and he files for divorce on her, and so, lo and behold, first wife wants to depose second wife, thinking that's going to help her in her case. However, they didn't ask second wife's lawyer to the deposition of her, and they asked all these questions involving the criminal case and pertinent to her divorce. Yeah, that was a problem. The court said that was a problem. So, we're still getting a number of complaints regarding attorney bypass, though. So here are some of my gentle reminders. Anytime a represented person is questioned about the subject matter of the representation, it can be a violation of 4.2. It is not case specific. This matters particularly in family law where you have all these cross activities. There may be a paternity case, and then there's a protective order case, and a post-dissolution motion from another marriage over here, and all these different things. If parties are represented, always remember, it's not a party if it's ex parte. It's not a party if you're violating the attorney bypass rules. So just invite everybody along, and then you're safest. And it applies to all forms of communication. And where we're seeing kind of a new growth of the violation of the attorney bypass rule is in social media. Younger attorneys are very savvy across social media networks, and they are using it for client communications, and they're also using it for advertising, and unfortunately some people get into dialogues with opposing parties. That's a problem. It applies even when you believe there is a perceived conflict of interest with opposing counsel. You cannot pull his client, his or her client aside saying, your lawyer really has a conflict. Those situations, again, the pen is your friend, just file a motion and let the judge decide. And again, like I said, applies to self-represented litigation, and for those of you who do criminal law, always be cautious with communications with co-defendants when they're represented by counsel. Alrighty, so our next big area is ex parte. And actually we had, on the judicial discipline side, that was sort of the flavor of the year, was ex parte, particularly, again, custody orders and chins and other juvenile cases. For lawyers, it's a really general rule. It's Rule 3.5, and it basically says you shouldn't communicate ex parte with a judge. It doesn't really give you a lot of guidance, does it? That's why you really should go to Rule 2.9a in the Code of Judicial Conduct. We'll go through that in a minute. But I want to do just a general review. I'm sure you've all heard this. The in re anonymous cases on ex parte custody orders is that when you are seeking an ex parte custody order based on an emergency, you must comply with Trial Rule 65B, which requires an affidavit or a verified complaint. You've got to allege the harm and that it's irreparable, and allege specific facts supporting it. And you have to indicate that irreparable harm will occur before the adverse party can be heard. And you must indicate what efforts you made to notify the other side or why notice shouldn't be required. Here's where the problem is coming up. Everybody, this has been taught for over a decade now, the ex parte custody order. Where I'm seeing problems is in proposed orders, where an attorney intends to only request a hearing, that they have an emergency situation in a custody matter, and they need it dealt with quickly, and they want to get on the expedited calendar. However, the proposed order is written in such a way that a judge who is not paying attention grants the relief. So be very, very careful in looking at proposed orders about what you are requesting. Because if that is granted, we're going to have to look at it on both sides of the coin. The lawyer who submitted the proposed order and the judge who granted it. All right. Our next ex parte matter is public ed.
It's mine.
Okay.
Thank you very much.
But the reason And the reason I put this here
Sure,
is
go ahead.
that do you know I got more questions about this public admonition than any I have in a long time.
Good.
And for this reason, she was trying to do the right thing. And I've said that all along.
Right.
She was trying to do the right thing. She had a child that was traumatized, allegedly traumatized by her father, and had indicated that to the guardian ad litem. And it was a contentious custody matter, and the judicial officer did not want the child to be re-victimized by continuing to be interviewed on the same information. So she wanted to take the guardian ad litem's notes from the interview with the child and make a determination based on that. However, the law doesn't provide for that. The law requires either that you have an in-camera hearing or that you provide that information to the opposing side. And in this situation, the child and the guardian ad litem really did not want father to have that information because of the child. That's why this is a public admonition, because it is a learning point that even when you want to do the right thing, we still have to be looking at compliance with the law. And in this area, it didn't allow for acceptance of notes. Yes, go ahead.
I would tell you, certainly I understand now, and I think part of the issue is that sometimes we forget, and I obviously forgot, that the guardian ad litem is a party to the case.
Yes.
And that just didn't even enter my mind once I heard what was happening. I acted impulsively, and I know that that was wrong, but I think Vince and I were just talking about
I
recognizing.
was going to say, before you talk anymore, do you want to discuss with a lawyer?
She and I are
It's over, it's over.
Yeah, she and
I mean, that is kind of, to be very honest, I wasn't certain that the guardian ad litem is indeed a party to the case. And so that was part of the reason why the mistake was made, also because I was very worried about the child. But
And that's part of the reason that I educate on that, because a lot of people don't know that guardian ad litem's CASAs are actually parties to the action. So if emails are being sent back and forth, or there are hearings, they got to be there. They are representing the interest of the child. And a lot of people make that mistake. So our second case is matter of day, which was also Chin's matter, involving children, and it was a Chin's matter. There was a history of unauthorized ex parte communication, primarily by email. And the defense had been that, this was an ex parte because it was for administrative or scheduling purposes. Here's the thing, though, and that's one of the big components of this case, is that the court highlighted this, is that this is Rule 2.9 in the Code of Judicial Conduct, and it is a lot more extensive about what ex parte is and is not. And so the general rule is that a judge can't initiate, permit, or consider ex parte communications about the substance of a pending or impending matter outside the presence of the parties or their lawyers. However, there is a safe harbor for administrative, emergency, or scheduling purposes, but there are 3 requirements to it. 1, it can't involve substantive matters. 2, the judge must reasonably believe that no party will gain a tactical or other advantage as a result of the communication. Think about this for a minute. When you're making scheduling, how many times that can be a tactical advantage? Which is why number 3, the judge has to promptly notify all other parties and give them an opportunity to respond. If all three of these are not met, the safe harbor does not apply. Now, this is the Judicial Code of Conduct. You're all asking, why should I care about this? Because guess what? If that communication occurs and the judge doesn't have the safe harbor exception because not all things apply, it's an unauthorized ex parte communication. That's why you should care, and that's why you need to know because in particularly smaller jurisdictions, I realize the communication between regular players is very familiar. Emails, we got used to email and doing things during COVID, and it can lead to these types of problems. All right. Our final one is matter of need. This was another kid case. Chin's case in which the children's foster parents intervened and had expressed an intent to adopt the kids. Simultaneously, paternal grandmother also intervened and filed for third-party custody. The judge held an in-chambers conference that was not recorded. During this in-chambers conference that was not recorded, substantive oral motions were decided. And the grandmother, the paternal grandmother, who was just outside in the hallway, was not invited to come in and participate even after her motion to intervene had been granted. So that was clearly an ex parte problem. But then also, the foster parents' attorney had been participating by phone because she was in Evansville and didn't want to travel for this particular hearing. After she got off the phone, when she thought the hearing was done, the judge requested that mother's attorney assist the court reporter for the minute entry as to what occurred. Unfortunately, their recollection and the foster parents' attorney's recollection of what occurred did not match, which is exactly why we have the ex parte rule. So that is our final case on ex parte that came out in the last year. So here are the lessons for everyone. Be cautious with your proposed court orders when you're asking for emergency relief. Trial Rule 65B has to be complied with to the letter. Be cautious with in-chambers meetings, especially if not all parties are present. Even if ex parte communications are not occurring, the perception problem becomes very real and is the quickest way to get a grievance filed against you. And be cautious about email. Make sure to CC all parties, even if it's for administrative or scheduling reasons. And remember that guardian ad litem and CASAs are parties. All right, social media. As I've already indicated, number of grievances concerning behavior online, attorney bypass violations, pretrial publicity violations, and bias and harassment. And I want to highlight a case out of another jurisdiction, but it is somewhat interesting because I wonder if something like this will ever come to Indiana. It was an appointed attorney, was representing a defendant. He's African American and of Muslim faith. Was human trafficking charges. And he found out later, he had actually pled guilty upon advice of counsel. He later found out that the attorney had been sanctioned by the state public defender for his online conduct, and for like 2 years they weren't going to be giving him any public defender appointments. And so he filed to get his guilty plea withdrawn in terms of post-conviction relief. And the question was the representation impaired by an actual conflict of interest because of racist and anti-Muslim animus and online? And the attorney had made multiple posts, and they were extremely biased. And in Massachusetts, they determined that there didn't have to be a showing that his animus, that it actually affected his performance, which I think is very interesting. I went and looked at Indiana case law. There hasn't been anything like that, but I kind of alert everyone that is potentially something that could be on the horizon, especially when we're seeing a lot of activity online. Fees. We have seen an incredible rise in complaints about fees. Now, normally, we don't entertain the typical fee dispute as an ethical matter, but we are starting to see a lot of viable concerns or unethical provisions in fee contracts. This is what has led to Advisory Opinion 2-23, which I would encourage you to review. Some of the highlights is it talks about non-refundable fee clauses, bad, unethical. Fee disputes, where you need to put your money in terms of IOLTA versus your operating account. I'm not going to go over that because Mark Cornell will cover that in detail. Excessive fees, commingling of funds, inherently unfair fee agreements, which, for example, flat fees, where you do not affect the purpose of the fee agreement and you don't return any money, that's going to be an inherently unfair fee agreement. And of course, you can't charge clients for responding to grievances. I shouldn't have to say that, but that happens. All right, so let's see if I can get... You also can't charge people. If you do a whole bunch of research, actually James Bell says it way more funny than I do, but you cannot charge people. If you do a whole bunch of research on a novel legal issue, and then you have another client come in the next day on the exact same legal issue, poor client number one, he's going to be charged for all of it, and you can't charge client number two for any of that big old bucket of research you did on the first one. You have to charge for actual client time. All right, so I would encourage you to read the fee advisory opinion because it goes through a lot of different issues, and again, through hypotheticals, it is quite useful, but I want to get through some of our other topics. So, Barb, do you want to pick the second category?
I was just going to tell you I like that you put the T in my last name. Thank you. Let's do advisory opinion.
All right. So as I indicated, conflict of interest was kind of the flavor of the year. And we did a general conflict of interest, advisory opinion 2-22. It's important to remember that the general rule is that if your advocacy is materially limited due to a duty to another or your own self-interest, then you cannot be representing that person unless they have given informed written waiver or if it's otherwise prohibited by law. That's the general rule. But there are a number of scenarios that go through Advisory Opinion 2-22, particularly prospective clients. For example, the quintessential conflict situation, again, family law is sort of the issue of the day. Husband comes in and wants to hire you, is talking about hiring you to represent him in a divorce. But he ultimately decides not to hire you. But he tells you all the facts of why his wife is a terrible person and all the money should go to him and the custody and all this sort of thing. And 3 weeks later, wife comes in and wants to hire you. you have an inherent conflict of interest. That's kind of the quintessential on prospective clients. Representing multiple parties, you always need to work through whether there are loyalty differences between the parties, co-defendants in criminal law, but you have somebody that is, you have three friends who want to start up a business, and two friends are going to put in sweat labor and one is putting in all the money. It may depend, but if it's a substantial cash outlay by one and minimal service sweat contribution by the others, you may need to tell the one with the cash outlay to talk to independent counsel about whether this is in their best interest. Personal conflicts of interest, always going to be a question, particularly if you go into business with a client. You must tell them to consult with independent counsel in order to get past those conflicts of interest. And then, of course, conflicts of interest arising during representation. It never stops. All right, imputed. This addresses when a firm has to either decline representation due to a conflict of one of current, future, or former attorneys. Remember that if an individual lawyer at the firm is conflicted, so too will the firm, unless the conflict is personal to the lawyer, and or affected clients give informed consent. Do you notice a pattern here? Informed consent being the important thing. It addresses ways for law firms to minimize needing to withdraw from representation due to the conflict of one attorney. Having effective screening mechanisms and setting up a wall so that, for example, an incoming attorney has no involvement in a matter in which they were conflicted and has no ability to access those files. It's very important to set up those procedures on the front end so you're not in the middle of a representation and suddenly have to get out. And again, obtaining informed consent when waiving, here are the rules involved. For departing lawyers, generally you can represent clients with adverse interest to a lawyer who has left a firm unless it is the same or substantially related to the work of the departing lawyer. And then government lawyers, somewhat nuanced, but interesting area, especially since we're having a lot of turnover this year with the governor not seeking re-election. You're going to have a whole onslaught of government lawyers out there. And going through the analysis for a government lawyer and whether they can work on matters at a new firm, the question is, was the lawyer previously personally substantially involved in the matter? If they were, have they obtained informed consent from the agency for the new representation? If those two things, if you get past those two things, the next question is, did the lawyer learn damaging confidential information about a person that will be materially damaging to a person? And that could be a witness, an opposing party, variety. It is not specific to just the parties to the case. And then finally, even if you get past all of that, the question is whether there would be any revelation of confidential information that, if that occurs, then they would not be able to work on the matter. All right, so procurums are on the horizon. Go with on the horizon.
On the horizon.
All right. Because I like doing on the horizon and I hate doing pictures. All right, on the horizon, AI is the topic that everybody wants to talk about, but there are some potential ethical issues. First is confidentiality. For those of you who haven't used ChatGPT or some of the AI research database, what you put in might flow out to someone else, is the way the system works. So if you're doing a research project and you're putting in client confidential information, you might get it on your next request. So that's potentially problematic under Rule 1.6. The bigger issue, and I have been told by different people, I don't use ChatGPT. I love Westlaw. I'm a traditionalist, and I am not real interested in AI. But from people that have looked at it, and my interns that I have them kind of looking at it, some of these bugs have been worked out. But still, I wouldn't be doing my job if I didn't warn you that ChatGPT has some truth and accuracy problems, which makes it a Rule 3.3 candor to a tribunal issue. Because ChatGPT, as I was told in a national presentation, is the ultimate people pleaser. As a woman described, she had used ChatGPT only to find out she was Harvard educated, summa cum laude, and had all of these wonderful, wonderful things on her CV that did not happen at all. Because ChatGPT wants you to like it. And so it will spit out information that it believes will please you in its request. I'm told that some of these bugs have been worked out, but again, under Rule 5.3, you have a duty to supervise even when using artificial investigation methods. So double check all work that you do on AI. So why does this matter? Well, if you haven't heard it by now, the New York case, Southern District of New York, federal case of Mata versus Avanica Incorporated. It was a personal injury matter in which a lawyer who wasn't really as familiar with federal lawsuits, federal claims, used the services of a friend of his who was really more of a state personal injury lawyer. He heard about ChatGPT, and so he used that for legal research for a brief, which was on the Monroe Doctrine, which was about the tolling of statute of limitations. Lawyer never used ChatGPT before, and he asked a broad question about the Montreal Convention. Then he began asking more questions. ChatGPT really wanted the lawyer to like it, so it fabricated 6 cases on the Montreal Convention. And the lawyer ended up putting those in the fabricated cases in the brief. So, yes, Rule 11. See, sometimes I am the least of your worries. Rule 11, that's where, all kinds of bad things happen. Opposing counsel notes in the response, hey, I can't find these cases. And so the judge says, pony up. Give me copies of these cases, because I can't find them either. And co-counsel, instead of doing that, submits an affidavit that only includes the case excerpts. Why, you may ask, did he do that? Because that's what ChatGPT did. Nobody had the real cases. And so the court issues a show cause order. Now, this is why things went bad, is that the lawyer doubled down at first. Instead of just admitting that he had made a mistake when the first shot across the bow went and opposing counsel said, I can't find these cases, getting to the point of a show cause order. So at the hearing on the show cause, he had submitted an affidavit just prior to that explaining ChatGPT, his use of it, and then he later learned that these cases were false. At the hearing, he says, my reaction was, ChatGPT is finding that case somewhere. Maybe it's unpublished. Maybe it was appealed. Maybe access is difficult to get. I just never thought it could be made up. So, I am a curious person. So I pulled the actual search history. So here's how the search history went down. ChatGPT had thrown out a couple of cases, and one of them is Vargas. Is Vargas a real case? Yes, Vargas versus China Southern Airlines. This is how I envision ChatGPT. Yes, Vargas versus China Southern Airlines is a real case. And she provided a site too. So the lawyer then says, what is your source? And ChatGPT says, I apologize for the confusion earlier. Upon double checking, I found that the case Vargas versus China Southern Airlines does indeed exist and can be found on legal research databases such as Westlaw and LexisNexis. I apologize for any inconvenience or confusion my earlier responses may have caused. Are the other cases you provided fake? No, the other cases I provided are real and can be found in reputable legal databases such as LexisNexis and Westlaw. Again, ChatGPT, the ultimate people pleaser. Just be cautious. So in the sanctions order, the federal judge noted that pursuant to Rule 11, that the filing of papers without taking necessary care in their preparation is an abuse of the judicial system, and not only does it potentially subject you to Rule 11 sanctions, it did in fact, with this attorney, it was a $5,000 monetary sanction. But even more importantly, the federal judge noted that New York's Rule 3.3A1, similar to our rule, that a lawyer shall not knowingly make a false statement of fact to a tribunal, or, and this is the important point from the case, fail to correct a false statement that was previously made. So, once again showing the pen is mightier than AI. All right, so it's not just AI, robot lawyers in court. Anybody heard about robot lawyers? Anybody heard about Josh Browden? Okay, so Josh Browden is an entrepreneur who has put out there, he's rather colorful individual, and he wants to help defendants fight traffic tickets, and he was going to do that in California on February 22nd. That did not come to pass. I'll get to that in a minute. He was going to do it with smart glasses that would record all of the proceedings and then with an earbud tell everyone what they should be doing with their traffic tickets. Anybody see the problem with that? For those of you that are thinking, practice of law, bingo, you win. The reason that he didn't do that in February is that he got questions from bar authorities. He wouldn't say where, but dollars to donuts, it was California, that sent him a letter. But that doesn't stop Josh. He apparently tweeted an offer to pay $2 million to a lawyer who has a case before the U.S. Supreme Court to use his technology to argue before the U.S. Supreme Court. No takers. All right, so our final category is per curiam opinions. I'm going to go over this very, very quickly. Sort of the messaging for this year was about sanctions. And there were 3 big sanction cases. The ethical misconduct was not novel. It wasn't particularly complicated. It was really more about the nature of prior conduct, or what I like to say, there's the first case, matter of Staples, was what we would call the serial offender. This was his 3rd bite at the apple. And he had been disciplined on 2 prior occasions. First time, I think, was a public reprimand. Second time was a 60-day without. His misconduct, however, was more garden variety in that he took money from a client and the client's mother, didn't do anything for the representation, had an office sharing agreement with another attorney, and had the other attorney appear for the client, even though there had been no discussion of that at the time of the fee agreement. They ended up having him, they terminated his representation, wanted their money back. He wouldn't give the money back, so they sued him in small claims court. Default judgment entered against him on the small claims. He still doesn't pay up, thus the knowingly disobeying court order. And then he made a couple of false statements in responses to the commission and not complying with the demand for information. So again, but the issue that is of note is that it was a serial offender. And because of this being his 3rd bite at the apple, the court said that other meaningful opportunities to get the attorney to come into line did not work. They kicked him out for, I believe it was a year without automatic reinstatement. The next individual, in matter of hardesty, was what I would call the blitz offender, where just all kinds of things happen on cases all at once. It wasn't a number of acts over a course of years, it's all at once. And he is two different cases in which he engages in neglect, not showing up for court on a Chin's case. In a criminal case, he shows up, jury impaneled, then tells the judge that he believes he was exposed to COVID, mistrial occurs. Case gets set again, another situation, neglect, mistrial again. So, as well, during this period of time, he also was arrested for possession of methamphetamine and had this criminal case pending, of which, and was convicted, I believe, and the court became aware of that. Because of the nature of his misconduct, and again, it was sort of a blitzkrieg type situation, they determined that he would be suspended for 2 years without automatic. Okay? And then the third is matter of McMahon. He had pled guilty in federal court to possession of child pornography with a 12-year-old. The court felt that it was important to write per curiam on this, mainly because they wanted to indicate that it would be extremely difficult. The burden would be particularly steep for him to seek reinstatement on this case. I think that one of the possession of child pornography, I'm not trying to minimize that at all, but the suspension was in line with precedent, but the aggravating factor that was not particularly highlighted was when the investigation first started. He was a judicial officer, not in your county, but in a different county. So that, ladies and gentlemen, is what we do, how we do it, and
hot topics in ethics this year.